A federal judge in New York has just denied the government's bid to unseal grand jury materials in the Ghislaine Maxwell criminal case. It's a decision that may frustrate those hoping for new revelations about Jeffrey Epstein's alleged network. But is this evidence of a cover-up, or really does it make legal sense? Time to break down the ruling, what this means, and what we should be looking out for next. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Well, a federal judge in New York has denied the government's petition to unseal the grand jury materials in the Ghislaine Maxwell criminal case. Now, I am personally not shocked by this, and I will tell you what, from a legal perspective, from a legal point of view, it makes sense. So for those of you who are skeptical of what is going on, right, might believe this is further evidence of a cover-up to hide evidence against potentially other people, right, from coming out, the elites, I'm going to analyze this 31-page decision from U.S. District Court Judge Paul A. Engelmeyer, okay? Because here's the thing. I think going through this opinion, picking out the big parts is really, really important, right? It shines a light on this not being a cover-up, but from a legal point of view, it makes sense why the grand jury materials will not be released. Now, remember the context of what is happening. People are hungry for more information about whether deceased convicted sex offender Jeffrey Epstein had a client list. Were the elites or prominent figures a part of Epstein's purported child sex ring? What other information is out there that we haven't seen? And this comes after a ton of blowback, including from supporters of President Donald Trump after the FBI and the DOJ released a memo last month that basically said after reviewing Epstein and Maxwell materials in their possession, there was nothing else to really release for the public, and no one else is going to be charged in this case. Well, after that blowback and accusations of a cover-up, President Trump ordered Attorney General Pam Bondi to release, quote, any and all pertinent grand jury testimony in the Epstein case. See, the problem with that, in my view, and we're going to get into this, is when this was announced, I said, this isn't going to satisfy the questions that people have. The grand jury testimony is going to be very limited. It's going to be very specific. And if you look at the judge's opinion, that is exactly what is going on. So let me go through the opinion. You'll hear the reasoning, and we'll talk about it. It begins, quote, the policy that proceedings before a grand jury shall generally remain secret is older than our nation itself. So why are grand jury proceedings secret? And remember what a grand jury is. This is a set of people who, through a majority vote, have to determine if there is probable cause, doesn't have to be unanimous, there has to be probable cause that a crime was committed. So is there enough to return an indictment? It says the purposes served by grand jury secrecy include to prevent the escape of those whose indictment may be contemplated, right? You don't want to tip anybody off that there's an investigation going. To ensure the utmost freedom to the grand jury in its deliberations and to prevent persons subject to indictment or their friends from importuning the grand jurors, right? No undue influence on the grand jurors. To prevent subornation of perjury or tampering with the witnesses who may testify before a grand jury and later appear at the trial of those indicted by it. To encourage free and untrammeled disclosures by persons who have information with respect to the commission of crimes, and to protect the innocent accused who is exonerated from disclosure of the fact that he has been under investigation and from the expense of standing trial when there was no probability of guilt. Now that's important. That's an important point. Basically, if a case is taken to a grand jury and they don't return an indictment, the accused shouldn't have to live with it being publicly revealed that he or she was under investigation and what the evidence was against him. This is about fairness. This is about secrecy. This is about maintaining the integrity of this process. Now, I say all that, but there are exceptions. The Second Circuit has recognized that in special circumstances, the disclosure of grand jury materials may be appropriate even where it is not authorized. The Second Circuit developed this doctrine in 3 cases where disclosure was sought of grand jury matters claimed to be of unusual historical or public interest. Argument here could be, my gosh, a lot of people are interested in the Epstein-Maxwell case. Now, we've been following this Epstein saga for a while, and the reason that we can do this, the reason we can stay on top of a story like this is because of the amazing support that we get from our sponsor, Morgan & Morgan. This is America's largest injury law firm. This is a firm with over 1,000 attorneys. You know why? Because they win a lot. They have recovered over $25 billion from more than 500,000 clients. In the past few months, a client in Florida received $12 million after the insurance company offered just $350,000. Out in Pennsylvania, the client was awarded $26 million. That is 40 times the insurer's $650,000 offer. Another client in Pennsylvania received $29 million. after being offered only $500,000. And even if you think your case isn't worth millions of dollars, why not just start a claim and fight for what you deserve? Morgan & Morgan makes it so simple. You can start a claim from your phone in just 8 clicks. So if you're injured, you can easily start a claim at forthepeople.com/LC Sidebar by clicking the link below or scanning the QR code on screen. The opinion goes on to say, quote, "The doctrine is to be applied only in exceptional circumstances, and it does not justify granting, quote, garden variety petitions for disclosure. No exception authorizes the disclosure the government proposes here of, subject to redactions, all testimony and exhibits before the 2 grand juries that indicted Ghislaine Maxwell. The government's motion to unseal does not contend otherwise. It does not argue that these materials would aid federal, state, military, tribal, or foreign law enforcement, or would be relevant to national security officials, another grand jury, or another judicial proceeding. Nor does the government, or Maxwell, argue that the materials would reveal a ground to dismiss the indictment against her. Any and such motion to dismiss on this basis today would very likely be futile because Maxwell's conviction at trial renders all but the most serious errors in the grand jury proceedings harmless. The government instead invokes the special circumstances doctrine on the ground that there is, like I said before, an abundant public interest in obtaining additional information about Epstein and Maxwell's crimes and the DOJ and FBI's investigation into them. However, the Maxwell grand jury materials the government represents are critical pieces of an important moment in our nation's history, and the time for the public to guess at what they contain should end. The government's invocation of special circumstances, however, fails at the threshold. Its entire premise that the Maxwell grand jury materials would bring to light meaningful new information about Epstein's and Maxwell's crimes or the government's investigation into them is demonstrably false. So now you'd be saying, why? Quote, "First, the grand juries in this case were not used for investigative purposes. They did not hear testimony from any first-hand witness to any event at issue. They did not hear testimony from any victim, eyewitness, suspect, or even a records custodian. The grand juries met instead for the purpose of returning an indictment. Each grand jury received evidence on a single day. On that day, it heard testimony from one person, a law enforcement agent who, acting as a summary witness, so this is basically somebody who actually summarizes all the evidence, testified to information obtained in the government's investigation to support the charges in the proposed indictment. The agent, responding to tightly structured questions from an assistant United States attorney, provided highly abbreviated, hearsay accounts of the statements of select witnesses, meaning the victims on whom counts in the proposed indictment were based. The agent led the jury through a PowerPoint of exhibits, photographs, business records. At the end of the testimony, the agent testified that he or she had not disclosed all that he or she knew, but had only responded to the AUSA's questions. Afterward, each grand jury voted to return the proposed indictment." Let me stop right there. This is totally normal. This is exactly what you see in grand juries across the country. This is a limited presentation of evidence by the prosecution. Yes, it's one-sided, but that's the purpose of it. It's not an examination of all the evidence prosecutors are going to introduce at trial. They just need to present enough evidence to get back an indictment. And in this case, and we're going to get into this, where it was only about Epstein and Maxwell and nobody else, this was a very limited presentation with very limited testimony. And why I said at the very beginning, when it was announced they're going to release the grand jury materials, it wasn't going to address anything that people were looking for. In fact, here's what the court says. The evidence put before the Maxwell grand juries is today, with only very minor exceptions, a matter of public record. This is an important point, too, that remember how much has already come out in this case? Even a few months ago when they talked about the Epstein records, Volume 1, all of that we already knew through releases from prior litigation. The flight logs, the contact list, we all knew that. If anybody's been following Ghislaine Maxwell's trial, they would have seen what came out. If you followed civil lawsuits, you would have seen what has come out. So that's when the court says all of this is already part of the public record. And the court says the government admitted as much in response to the court's order. The enclosed annotated transcripts show that much of the information provided during the course of the grand jury testimony, with the exception of the identities of certain witnesses, was made publicly available at Maxwell's trial, which, by the way, was fully reported on, or has otherwise been publicly reported through the public statements of victims and witnesses. The court's review confirmed that unsealing the grand jury materials would not reveal new information of any consequence. In response to the court's order, the government supplied the court with a binder highlighting any information that the government had been unable to determine as public. Only scattered words, clauses, occasional sentences are highlighted. These items are few and far between. The highlighted snippets supply at most tertiary details about the same conduct that was the focus of Maxwell's month-long trial. The same is so for the exhibits put before the grand juries. Save inconsequential portions of a few exhibits, these were received in evidence at Maxwell's trial. Some were reproduced in the Maxwell indictments. A member of the public familiar with the Maxwell trial record who reviewed the grand jury materials that the government proposes to unseal would thus learn next to nothing new. The materials do not identify any person other than Epstein and Maxwell as having had sexual contact with a minor. They do not discuss or identify any client of Epstein's or Maxwell's. They do not reveal any heretofore unknown means or methods of Epstein's or Maxwell's crimes. They do not reveal new venues at which their crimes occurred. They do not reveal new sources of their wealth. They do not explore the circumstances of Epstein's death. They do not reveal the path of the government's investigation. In other words, everything the public's looking for, this ain't it. This isn't going to be it. Remember, Ghislaine Maxwell was prosecuted for sex trafficking minors over a 10-year period to solely Jeffrey Epstein. That's what that criminal case was about. So what we're saying is none of this should be surprising. This is standard for a grand jury, and this is standard for a case like this. And the judge said, yeah, the trial consisted of testimony of victims, law enforcement photos, items collected from Epstein's homes, flight logs, address book, but again, all public record, all reported on. The one colorable argument under that doctrine for unsealing in this case, in fact, is that doing so would expose as disingenuous the government's public explanations for moving to unseal. A member of the public, appreciating that the Maxwell grand jury materials do not contribute anything to public knowledge, might conclude that the government's motion for their unsealing was aimed not at transparency, but at diversion. Aimed not at full disclosure, but at the illusion of such. This court gave careful consideration to unsealing the Maxwell grand jury materials on a similar rationale, but with the government having now conceded that the information it proposes to release is redundant of the public record, that this information was made publicly available at Maxwell's trial or has otherwise been publicly reported, the public interest in testing the government's bona fides does not require the extraordinary step of unsealing grand jury records. Without any need to review the grand jury materials, the public can evaluate for itself the government's asserted basis for making this motion. So in other words, we don't have to unseal anything. The fact that the government just admitted there's nothing new, you conclude what you want about why the government had moved to unseal these materials. And then the court goes through a number of factors to determine if unsealing is warranted. Number one, identity of the party seeking disclosure. So normally the government's position is given great weight. However, here the motion apparently wasn't filed by the DOJ trial team, but by the Deputy Attorney General alone in what they call as a hasty and irregular manner, without supporting materials or victim notification. So this factor, according to the court, favors disclosure, but was given limited weight due to procedural irregularities and a lack of compelling need. Two, opposition from Ghislaine Maxwell, right? She's the defendant, opposes unsealing because she has an ongoing appeal, and that's important. This is where the court acknowledged her objection, assigned it limited weight because she hasn't seen the materials. She may be unaware if they're duplicative of trial evidence, but remember, she has an ongoing appeal. She's trying to get the Supreme Court to hear her case. She doesn't want to have anything come out that could jeopardize that. If her convictions are thrown out and she gets a new trial with a new jury, she doesn't want any of this to affect that jury. It's an interesting factor. Another one is purpose of the disclosure. The strongest factor here against unsealing, because the materials, according to the court, are not historically significant, offer no new information beyond what was presented at Maxwell's public trial, that the public interest argument was deemed too vague, unsupported by the actual contents of the grand jury transcripts. What about specificity of the request? Well, the government seeks blanket disclosure of all grand jury materials. The court said this was broad, it was untailored, it weighs against unsealing. Timing, another factor. The grand jury met only about 5 years ago. The trial was under 4 years ago, so this contrasts with cases where disclosure was granted decades later. This factor weighs against unsealing. Status of the principals and the families, while Maxwell, still alive, could theoretically be harmed by disclosure, as we talked about. The content is already public, so this factor is kind of neutral. Extent of prior disclosure, most of the grand jury material has already been made public during the trial, so this factor supports unsealing, but the court balanced it against systemic concerns. Living witnesses, the law enforcement agents who testified are alive, but their identities could be redacted. This factor is neutral. Need for secrecy, the proposed redactions would protect privacy. This factor is neutral. Victims' perspectives, well, victims largely support disclosure, provided identities are protected. However, the court notes that their support seems based on the mistaken belief that the materials contain new information. This factor would slightly favor unsealing, but there's reservations there. And then, of course, the systemic interest in grand jury secrecy. The court emphasized the importance of maintaining grand jury secrecy for future proceedings. You don't want to set a dangerous precedent that disclosing these materials would do that. It expands what we mean by special circumstances, that exception. So this factor weighs heavily against unsealing. And in the end, the judge denied the motion to unseal. And of course, it becomes a question, is this a good thing or a bad thing for the Trump administration, right? The president has been accused of downplaying the significance of the Epstein materials, not revealing that there's more there. And there's, of course, what's happening with President Trump suing the Wall Street Journal, reporting that he sent a bawdy, controversial birthday letter to Epstein in 2003. He adamantly denies that. So here's the question. Can they just say, we tried to release certain things, the judge wouldn't allow us to do so? That might be an argument. And now you talk about what happens now. Well, NBC is reporting that a similar DOJ request to unseal records in the case against Epstein is pending before another judge. I can't imagine, I'm sure there's a possibility, but I can't imagine there would be a disagreement here. I think this is an incredibly compelling argument, and I wonder if the other court would ultimately agree. But you also wonder, is the administration really going to fight this? Or again, say, hey, we tried our best, the court disagrees, that's it? That may be it. We'll watch and see. All right, before we wrap things up, little programming alert. I'm going to be hosting Cuomo tonight on News Nation, 8 p.m. Eastern. And one of the things that we're going to be doing is taking your calls. So about any case that we have covered here on Sidebar, any of the big true crime cases, call in tonight, 8 p.m. Eastern. I'll be filling in, hosting Cuomo on News Nation. I'll put the call-in number on a social media post, and you'll make sure to call in and ask some questions. I'll see you then. And that is all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.